Welcome to the Low Law Podcast, Justice in West Texas.
Welcome to the Low Law Podcast, Justice in West Texas, with attorney Tara Gilmore-Low, founder of the Low Law Firm in Abilene. Tara has spent more than 20 years helping injured West Texans and holding businesses accountable when preventable dangers cause harm. I'm Chelsea, and today we're talking about slip and fall injuries in stores and other businesses and what actually counts as negligence under Texas law. Welcome back, Tara.
Hi, Chelsea.
This is a hot topic.
It is a hot topic.
When someone takes a fall in a store or at a business, what are the first things you look at to figure out whether the property owner might be responsible?
Well, the first thing we got to look for is what caused the fall. And if what caused the fall could have been a condition that was created or known to by the premises owner. Premises liability cases in Texas are very difficult, and people never understand that. But to answer your question, the very first thing we're going to look at is what caused them to fall.
What kinds of unsafe conditions most often lead to falls in West Texas? Things people might not notice.
So I'm going to go with liquids on the walkways. Usually it's liquids. Nearly every case, not all of them, but nearly every case involves some sort of liquid that's been left unattended on the floor somehow. And when I say liquid, I've had it be eggs. It could be, it could be a number of things, juice, soap, Coke, all kinds of stuff. The other big one would be deviations in the walking space. There's some very interesting guidelines that all of us are supposed to follow when it comes to basically the flatness of your walk area. And probably no one does, but there really should not be a deviation in the walking space without some sort of notice more than about a quarter of an inch. So
you mean like a different level or switching
Correct.
levels in the floor?
Correct.
A lot of folks feel embarrassed after a fall and maybe just want to get up and walk it off. Why is it important to stop and to report the incident right away?
Because if you stop, and I know it's embarrassing, I get it, but if you stop and make that report, even though that report that is taken by that store manager or whoever their safety person is or whoever is not probably going to be all that favorable, and they're going to put everything in there that they can that doesn't help you, it's still going to give us a lot of information. Also, somebody's going to take pictures, and I'm hoping it's the person who fell if they can. But either you, the people with you, somebody who saw it, somebody's going to be taking some pictures while you're sitting there. But getting that report done, it documents the time, the location, probably everybody's idea of what the substance is or what caused the fall. And it gives us the name of the manager, gives us the name of the employees who might have seen it, who might be taking the report. It gives us a bunch of information. So it's very helpful to document that fall. The other thing is I have had clients who did not document their fall. And it creates issues later, especially if your treatment is sporadic after the fall, like you don't go get treatment right away. I've had defense lawyers say there's no record of this fall. We have no video. We have no report. We have no nothing. So documenting that fall is very important.
What should someone do and not do in those first few minutes after getting hurt on someone else's property?
So the first thing you need to do is make sure you're okay. Before you move, take stock of yourself and see, are your legs working? Can you stand up? All of that. That's the very first thing that needs to happen. And then, I would have someone, 9 times out of 10, somebody's going to notice your fall and say, hey, can I help? It may not be store employees. It may be customers or someone else, patrons, something. Get help. And then just tell them what happened if they ask.
Without sharing any identifying details, can you describe the kind of situation you see with clients where a small detail in the scene maybe made a big difference in the case later?
I can. I actually have a very good example of this. And this is a case from a few years ago that I'll never forget. Getting those details whenever you have fallen is very important. And we were involved in this case. It was a grocery store case. And it was liquid on the floor. And the client said she was pretty sure it was water. We're like, okay, we're litigating. And it comes to, we're answering discovery. And at this point, my appellate lawyer and I are both thinking, we're not going to be able to make this case. We have no clue how they thought. And so we're talking to her, we're doing the discovery. It turns out that one thing that she remembered was dirt tracks going through the water. And the reason that was so important is it showed that water had been there for enough time that someone else had gone through it and tracked that water off with their basket. And so those dirt tracks became very important in that case because it gave us a leg to stand on to show that water had been there for a while. It wasn't just spilled there right before the client stepped in it.
Yeah.
So that was very important.
Businesses sometimes claim they had no idea about a hazard. What types of things can show that they should have known it and should have fixed it?
So, well, that's one example. When you're talking about liquids, those are always real difficult to show that the business owner should have known because someone can drop. You got kids, especially like if you're at like a big retail store, you're going to have kids going in and out with liquids. They may spill it. The employees may never have any idea. But other conditions that like holes in the parking lot, again, I can't say this enough. Premises cases are not good in Texas, but for the moment, let's assume you've got a hole in the parking lot. And if the place has been there for a long time and the hole just keeps getting bigger and bigger, well, I mean, they're going to have inspected their parking lot at some point. So they're going to know that hole was there. And if they've put up no warnings and taken no steps to keep people from having to traverse through it, that's a problem. That could be a problem for them.
How can things like store rules, cleaning schedules, or camera footage help show whether the business did what it should have done?
All of those things help both sides. You know, I have sued some companies that are very good. They have very good inspection schedules. There are some companies that have specific employees to walk their floors every hour, 30 minutes, something like that, depending on who it is. And so they have some very good policies, and those policies will protect them. When they don't have those policies, it helps us. Video footage, hugely important. And I have a funny story that will go with that. A bunch of years ago, I had this case. Sweet little old man. And he had fallen in a big retail store. And he had hurt himself. And he was the sweetest man. In this case, the adjuster called me. And she said, Tara, I'm going to send you the video footage. And I said, oh crap. I said, okay. That never happens before a lawsuit's filed, hardly anymore. Every once in a while. I said, okay. And she said, and I want to stay on the phone with you while you watch it.
Okay. What was on it?
I said, okay. So we watched it. There was a very large puddle in the floor. Very large. And we watched my sweet little client walk past the puddle, look at the puddle, come back, and then go jump in the puddle.
Oh my gosh.
Yep. So video footage can help everyone, not just the plaintiff.
Wow.
Yeah. So all of those things are very helpful, and it's helpful to both sides, but not every business will invest the money to do that. And they also don't want to. It's a lot easier to say we didn't know. So
what tends to happen when someone delays medical care or they assume, hey, my injuries are just minor after a fall?
Well, that is the same advice. That response is the same across the board for nearly any type of liability case. Okay. And it is the longer you wait to get medical treatment, the bigger window you are giving the defense to say that your injuries are not related to that accident. So, and it's a difficult balance. You may or may not have a claim. Who knows? You need to go talk to someone and find out. And if you don't have a claim, you may incur some medical bills. But here's the real question. If you're hurting, go get checked out. It doesn't matter if you've got, I mean, if you don't have a liability claim, you don't have a liability claim, but you still have injuries. So it's not going to hurt you to go get checked out. And like I said, that answer is across the board, whether it's a car wreck, an oil field accident, a premises case, an 18-wheeler accident, whatever it is. Don't give them a window to say your injuries are not related.
What are a few concrete, I know, like, great advice, a little stressful. What are a few concrete things that someone can do after a fall, like keeping records, saving receipts, or following up with doctors? What should they do to make a real difference in these cases?
Well, with premises cases, your injuries are your injuries, whatever they are. Yes, definitely follow up with your doctors. The real issue is documenting what happened and what caused that fall, and does negligence exist under the current state of the law in Texas. When it comes to your injuries, yes, follow up with your doctors. If you want to document some stuff, that's fine. I think it might help you. Some people, it just makes them feel better to do it. Keeping receipts, that's always helpful, especially for us. If you keep receipts, that's stuff that we may not always use it in your case, but we need it to get that information and make sure it's correct. So that definitely helps. But as far as the injuries go, following up with the doctors and doing what they say, very important. I have a lot of clients who just ignore doctor's orders. I don't even know why you go if you're just going to ignore the doctor's orders. Mm-hmm. I mean, follow the doctor's orders and do what they say. If the doctor says don't go to work for 72 hours, you have a choice to make. Either you're hurt and you need to recoup, or you're not that hurt and you want to go to work. I'm good either way, but you have a choice to make. But you need to be following the doctor's orders if you have a claim you're wanting to pursue.
Excellent tips and a few laughs. Appreciate this episode, Tara. So that's it for today's episode of the Low Law Podcast, Justice in West Texas. If you've been injured in a store or business and you're not sure whether negligence was involved, Tara and her team are here to help you sort through the facts and understand your options. Visit lowlawfirm.com to learn more. Thanks for listening, and don't forget to subscribe, share the show, and leave a review if you found this episode helpful.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.